according to the bail, it's called the Bail Reform Act, and it has a lot of considerations for the judge, okay? And one of the considerations is the character of the defendant. And that's why I offer his character. But you notice one thing? That's King Solomon. He made a perfect decision. He didn't win, I didn't win. And that's what you have, because this is not evidence. This is trying to persuade the court. Very good question.
Okay, so if no questions now, we just first
Excuse me,
section.
Your Honor, if we were just a procedural question.
Yes.
If we're running a little short in time.
Okay, yes.
I was gonna say, let's skip the suppression and go to the sentencing. That's an idea. That's
Good
okay.
question.
It depends upon the group. If they wanna hear it, I don't know what your schedule is. We've been here 45 minutes.
No, it's no other problems.
No problem?
Time is okay. Yes.
Okay,
yes.
time is okay. We'll
Yes.
go through
All three, yes.
all three.
Okay.
No problem?
Yeah. So the next section is the suppression hearing. We have a chance to is the one is for the search, one is for admission. Yes. Yeah. So first, I'd like the professor to explain what's a suppression hearing.
Okay. First of all, I have to defer to my worthy counsel.
Yeah.
Because it's his burden to use the motion to suppress. And therefore, he will explain why he comes forward on using it. The principle about suppression of evidence is it's the same in your law. There's an illegal search, the results cannot be used. It's involuntary confession, it cannot be used. In this case, it was the search of the house that led to the computer that led to the overseas bank account. And there's also an argument made by the defense that if the search was impermissible and the information about the bank, which was used by the FBI agent, the argument could be made that the statement would be excluded as the result of the search. It is called the fruit of the poisonous tree. They would have never had the information about the bank unless they had got it through an improper search. The issue as to the statement raises two issues. The first, as to whether or not a person was given a right to have counsel. Did the defendant express counsel? At this suppression hearing, we have not heard from the defendant. At this administrative hearing, we heard from the agent only. And so therefore, the court is bound by the determination of the agent's words. The defendant might have said something other to the police, might disagree with the agent, but did not testify. So the words of the agent, unless in some way compromised, and there's no contradictory evidence, have to be accepted. The second question is to whether or not the mention of the possible loss of the job would make the statement involuntary. And so with that, the defense would go forward, and our position would be that these statements and the results of the search are admissible.
Procedurally, and also this brings up the importance of advocacy for a fair trial, which is tied directly to human rights, the rights of this individual. Procedurally, what happens is many lawyers will get reports from the government after the bail hearing. There will be no trial set. The first hearing that is scheduled is for a motion hearing, so that the lawyer for the defense can think of legal issues that should be litigated. In this case, the defense attorney determined that the search warrant maybe permitted the police to go seize the computer, to go search the apartment. But the search warrant did not allow the government to conduct a second search, penetrate the data in the computer. There's newer cases that say you cannot do that. You have to get another warrant when you find a computer, okay? And what Professor Cleary mentioned is very important. A phrase, fruit of the poisonous tree. That comes from the 1930s. 1921. See how good it is? Wong Sun. Wong Sun is the name of the case. And the theory is very simple. If the government has a poisonous tree tainted with dirty hands when they go in the courtroom, they cannot use the fruit. The fruit is what they found inside the computer. But is that searched legally? So the lawyer will file papers with the court requesting a hearing. So Professor Clear is correct. I would have the burden because I'm the one that said, wait a minute, I know there was a search warrant, and many lawyers, unfortunately, many defense attorneys give up the fight when they see the search warrant. Because it says they have a search warrant, so the search is legal. Many lawyers, unfortunately, stop there and they don't challenge. In this case, there was a good lawyer. So the lawyer filed a motion arguing, number one, there was no probable cause to search inside the computer. There was probable cause to search and search the apartment and seize the computer. Maybe take it with you, but then you need another warrant. You have to go back to the judge and get a warrant for this. Second, the other motion to suppress is that the Fifth Amendment, Ernesto Miranda, your Miranda rights, the Fifth Amendment does not allow the government to interrogate a suspect illegally. And therefore, the interrogation of the FBI agent at the school of these young men was intimidating, and at the same time, although he was not arrested, the agent gave him his constitutional rights. So the lawyer thinks, why would the FBI agent do something he did not have to do legally? He wasn't arresting him, although he had probable cause. So what he did is he said, listen, I'm going to give you your Miranda rights as though I just arrested you, but I'm not arresting you, okay? So he gives him the Miranda rights. One of the Miranda rights, besides remain silent, is you don't have to talk to me without a lawyer being right here, okay? He's 24 years old. He's from China. He's into finance. He doesn't know the nuances of criminal procedure, okay? So the lawyer thinks, I'm going to file a motion because this is an involuntary statement. Involuntary statement because although he was not in custody, he did not feel that he could leave. If you're walking down the street today and you're going to your home, okay, and a police officer with a uniform stops you and says, young lady, I want to talk to you. You're not arrested. But do you think you could go away and not talk to the police officer? Same in America. So the argument by the defense to suppress is, wait a minute, he didn't feel free to leave. And when you tell this poor man, you have the right to a lawyer, but you don't need one. If you get a lawyer, that's bad. They'll fire you. That's intimidating, and that's equal, listen to me, equal as if you hit him with his fists. Because you can have a physical hitting or a mental hitting. Either way, it's involuntary. So we move to suppress based on involuntariness. And then later, the judge has the hearing, and then it depends on who has to go first. Sometimes the prosecutor goes first, sometimes the defense goes first.
Okay, thank you. Both of you. So give various explanations about what is suppression theory. So now we move to the second stage. So I have read your motion and response. So FBI agent testifies. The counsel, are you ready to proceed on the suppression search? Yeah.
Would you?
Yes. So first, I would like to the defense or counsel.
Thank you. Yes. Thank you. Your Honor, we're going to pretend that the FBI agent testified. We're going to pretend that he did not testify. Then I have to tell the judge why he should grant the motion. Your Honor, I'm going to do something very unusual in this case, sir. You heard from one witness, the FBI agent, and I assume that my colleague is going to come back after I sit down and say, well, he didn't testify. As you know, Your Honor, he doesn't have to testify, okay? But even without that, let's take the FBI agent's testimony to you, sir, under oath. The FBI agent told you that he found evidence, and I'll address the computer search first. He found evidence in that computer only after he went and looked inside of it. And they didn't search it in the apartment because they didn't have the equipment. So the poor FBI, with all the millions of dollars they get every year from the government, they didn't have the equipment to search a computer at the scene. But I suggest that's not the reason that it wasn't searched at the scene. The agents knew they had to get another warrant because that's search within a search. So after they found the data in the computer, then they went and investigated some more. I would suggest to the court that the penetration of that computer is another search as though it was another residence and they needed an independent warrant. And you know that that's what the law from the Supreme Court says about cell phones and about laptops and about computers. So we'd argue that the search of the computer itself was unlawful. They needed another warrant. Therefore, the search is without a warrant and is not justified. Second, the statements obtained from this young man. I will ask you because the prosecutor is probably going to say this to you. He's going to say, you didn't hear from this defendant. Again, he doesn't have to testify anymore. It is the government who has to justify the search. And the FBI agent told you something very interesting about the statements. This is an experienced FBI agent. He goes, after he searches the computer, by the way, he was not arrested when the computer was removed. So the agent goes back, and where does he go? Not to this young man's apartment. He goes into the school where all his friends and colleagues are. And here's this FBI agent, and with a badge. I want to talk to you. Well, the FBI, you saw the FBI agent testify, Your Honor. He didn't say, I told the young man that he didn't have to speak to me. He didn't say that. He said to you, although he wasn't in custody, I went ahead and was very nice. I gave him his Miranda rights. Your Honor, why would an FBI agent, trained, experienced agent, do something he doesn't have to do? If he's not in custody, Miranda is not triggered, as you know. So, but the agent believed that he had to give him his rights. I submit to the court that this agent knew that he had to because this young man was scared, his demeanor was such, and although you didn't hear that from the report or the testimony, you can infer that as a logical inference. So then what happens? You know that an involuntary statement, even after Miranda, if there's some coercion involved, it is totally inadmissible. Totally. So what happens? Here the FBI agent testifies to the court. You saw him. He said, yes, I gave him the right that he sort of made equivocal things. He's 24 years old. He's not a trained lawyer. What did this 24-year-old student in finance, by the way, not law, what did he say? Well, maybe I should have a lawyer. What else is he going to say? That's an invocation of his right. This trained FBI agent instead says, no, you don't want a lawyer. That's worse. What do you call that, Your Honor? When a law enforcement officer that should be professional with a 24-year-old kid, he's supposed to say, okay, you know what, you're right. Let me have some time and you talk to a lawyer. No, he didn't say that. He says, if you don't talk to me, you're going to get fired. I'm sorry, Your Honor. Under any interpretation, that's a coercive atmosphere. Therefore, any statement provided by this young man under those circumstances is not involuntary. Thank you.
Briefly, as to the search, the whole concept of the search, protect the Fourth Amendment, is to ensure that the police are supervised, that there is judicial review of their actions. In this case, the search warrant reads, you can search his house and all the contents therein. The argument made here by counsel would be, why? You found a locked refrigerator in his house. The court has approved the search of the house and all the contents therein. Now do they have to go out and get another search warrant so they can come in and unlock the refrigerator? Nonsense. Because the Fourth Amendment is determined by reasonableness. And therefore, under these circumstances, the protection under the Fourth Amendment was satisfied by a judicial officer giving the permission to the law enforcement officers to search a house and all the contents. And that is sufficient. And the reasonableness of it. And that is the reason why we have the protection. Because when you go into any house today, can you expect the normal contents not to contain a computer? So it's like saying, well, you can't search a computer. Yes, there is law dealing with cell phones in a unique context, but not where a order of the court says, officers, you can go forward, because the Fourth Amendment is not unreasonable in its application. It takes into consideration what reasonable law enforcement officers would do. Second, and it's to the state. I love counsel dearly. He's a very qualified guy, very experienced, but he twists the facts here. He says, inferences. Now, this is really interesting. We're not raising any question about the failure to come forward and testify in this hearing. That's not before. We're not before a jury. We're before a judge alone, who can be very rational and considerate. Heard only one version. He threatened my client. Whoa. This agent never threatened him. He takes and twists the giving of a Miranda warning sought by the United States Constitution, implemented by Miranda in 1966, and flips it. If the agent had not given a Miranda warning, would counsel over there be jumping up and down, shaking his arms and fists? Oh, they violated my Miranda rights! Oh, he'd be going through the ceiling. But because the agent were not required, because the agent could come out, grab him by the scuff of the neck at school, drag him down to the FBI interrogation room, put the lights and the cameras on him, and talk to him there, now that might be a little coercive. Now you got to give the Miranda warning. But out at the school, with his fellow students around, can I have permission to talk to this man? The agent comes in, shows his badge. He's required by law and agent regulations to always identify yourself when you come in. It's being flipped. And then we have, well, he gave a Miranda warning. You have a right to remain silent. Anything you say can and will be used against you in a court of law. If you do not have funds, counsel will be provided for you. He's saying, what? The very thought that, would it help me if I had a lawyer? The Supreme Court of the United States has directed that issue. Out of here. Unless it's clear and unequivocal. I demand a lawyer. Now you get a lawyer. I think it would be nice to have a lawyer. Wouldn't it be a good idea to have a lawyer? Zap! Out of here. No way. Now we go to the, I love it, involuntary. With this guy hanging by his thumbs in the interrogation room, we see the agent giving a couple of punches. Hoom! And the defense counsel tells us, get over this. The words can hurt my poor tongue. Just think of those nasty words driving right through my heart. How terrible those words were. What were they? Miranda rights? Because you were indicted, formally charged, grand jury having heard your case. Probable cause determined that you have committed these offenses. And the agents come out to talk to you about this charge. And now you say, the company put me on leave. Did the FBI agent put him on leave from the company unpaid? No. And if you're an employee in a bank and they're making an inquiry concerning losses of this amount, you would think a normal employee should cooperate, not the agent's turf. He said, is it not possible that you might lose your job for failing to cooperate on this issue of what's going on? That is not an involuntary statement. It is a comment on what might be a probable consequence of what could occur. He's not saying, I'm going down to the bank and make sure you lose your job. Totally different. Counsel is trying to bring in through the back door, contrary to what we heard the agent say here. In a nutshell, This was a valid search. It's a good statement, and both motions should be denied.
When I was a young man in law school, Your Honor, I learned a great saying that's been very helpful, and indeed I saw it materialize before me. I was told as a young advocate, when you have the facts, argue the facts. When you have the law, argue the law and the facts. When you have neither, pound the table. That's what he did. Your Honor, with all respect to my learned counsel and teacher, this was not a search of a refrigerator. There is specific case law that applies to a computer and a cell phone. And that is precisely why when you are a very good FBI agent, presumed to know the law, such as showing your badge with this 24-year-old, the FBI agent in this case, Your Honor, you see it, he applied for a search warrant for the homes. What we are supposed to do here now in the 21st century is to put in the contents of computers if some are seized. That's particularity, specificity required by the Fourth Amendment. That was not the case. Second, the agent did not merely read Miranda warnings. Had he done that only, it would have been fine. The agent did a little more. What did he do? He conflated two issues that are completely separate and independent of each other. As intelligent people, you must ask yourself, why did he have to say, oh, you are on leave from your job? You've been arrested. He hasn't been arrested yet. He has not been arrested yet. Precisely the argument, why then did he give his Miranda warnings if he's not arrested? That's a bankrupt argument. We pounds the table. So what happens then after that? An FBI agent does not have to hang someone like in the mid-century Europe when they used to hang people by their thumbs. That's prehistoric almost. No. A psychological coercion is just as powerful, as we know, Your Honor, as a physical one. There is no need whatsoever for the agent to go beyond, young men, you have the right to have a lawyer present. And maybe because he gives a vague request, maybe I should have a lawyer. There is a case right on point from the U.S. Supreme Court that says that is questionable invocation of his rights. So I ask you, Honor, under a reasonable standard, what's an FBI agent supposed to do under the law? When you get a questionable invocation of Miranda rights, make sure that this 24-year-old kid is communicating properly. Young man, why do you say maybe? Engage in a little discussion. Fair. And if he says, well, I'm scared, maybe I should have a lawyer present. And then say, well, let me tell you that you have the right to do that. No, the FBI agent did not do that. The minute the young man made a general invocation, maybe I should have a lawyer, what did the agent come back with, Your Honor? Oh, you're going to lose your job. So I ask you, sir, what was the motive of the FBI agent to say to this young man, if you don't talk to me, you're going to lose your job? What do you call that? What was the need for that? It was to overcome his will to persuade the fellow. Oh, he wasn't hung up on thumbs. That's not what we're arguing. The professional FBI agent did not have to threaten a 44-year-old kid with losing his job. But in fact, he needed to do that. That's called coercion, psychological coercion.
Okay. So I heard just looks like that's the arguments. So now I would like to deny the suppression of the search of the computers. Okay. So thank you. So this is the first sections of the second part. Okay. And we still have the. So do you have any questions? So you can see the differences of this time the arguments or the skills used in these sections is different from the used just in the previous sections. So and in particularly so the pencil. So this is a very this is learned from nowadays, law students learn from the law schools. So if you have the facts, argue the facts. You have the law, argue the law. You have neither of the nothing. You have nothing. So why he punished? He give it back. Yes. So this is have a very strong implication. Sometimes you should use in the court arguments. Okay. So this is not only just the arguments, legal argument for the law, but actually, so this is really the technical skills just be used in the court defense with the arguments. So this is I think it's very impressive. So and then we move to the second suppression, the hearing on the admission. Okay. So the FBI agent and defendant have now testified. Are you ready to proceed on the suppression of the statement? Okay, so first I would like to ask the counsel, the defense counsel.
I thought we did that, Your Honor.
We did
We addressed this.
You just have to rule on it, that's all.
Yes, we just have to rule.
Because of the rules, okay, yes, sorry. So, denied.
That's realistic.
Yes,
It's real.
yes, denied, okay. So, and then, any questions? Which challenge? So let's hold the table. Yes, please.
A very short comment. Because I noticed that attorney, when you make your statements, you use some of the storytelling skills. I think when I was a law school student, my experiences in law school, it's like a persuasion strategy for my understanding using their advocacy process. My question is whether it's a common skills or strategy used in U.S. court, because according to my limited experiences in China, we don't find lawyers use this to persuade the judges or the jurors. So my question is about, is common or it's not? Yes.
Very common. And let me answer your question with a question, if I may.
Yes.
What definition would you give of the word advocacy?
It's more like a debate or a logic reasoning.
You said logical reasoning. Logical reasoning, I submit, needs no advocacy. How much is 2 plus 2? Why would you need to convince someone that 2 plus 2 is 4? So what does advocacy mean?
It's kind of at least according to your performance, I think it's like comprehensive strategy used to draw people's attention and persuade people.
Correct. And it is not only allowed in the United States, indeed, it's encouraged. Otherwise, you would not have advocates, you would have robots. Because then there would be no need. So it is extremely invited. And Professor Cleary recommends a movie that everyone should watch. It's an old movie from the United States. It's called The Verdict. And why is that a great recommendation? Because I do the same to highly experienced lawyers when we have workshops. We take one weekend, we go somewhere with no phones, no computers, no email, and we ask ourselves, how can we be better? Okay? And the reason why The Verdict is very good, it answers your question. When you see the closing argument, that was a civil case, but the advocacy is the same. In a closing argument, a drama-inclined advocate like ourselves, the ones that pound the table, okay? And the reason why he pounded the table is because I did it too. You see, we're picking each other's tactics. He's trying to off-balance mine. That's good advocacy, if I may say. In The Verdict, the closing argument was about 5 minutes. He did not cover all the facts. He did not cover all the evidence. He just got up in front of the jury. You see it. You have to see it. Get it on Netflix. He gets in front of the jury and just speaks philosophical, ethical things for 5 minutes, and then he sits down. That's not a closing argument. Yet, it was extremely powerful because his advocacy, his dramatist, which was very honest, See, he was an alcoholic attorney who had fallen off the profession. So he came back to the profession because a woman needed him. So he stopped drinking. So when he talked to the jury, he talked from the heart. That's the quintessence of advocacy, young man. Because you can move a human being to do what they would not do.
If I can just briefly comment on that. I can fully concur with what he said. And this is the problem I faced in Russia. I was in Russia for 8 years at Moscow State University. And 3 years here in China, so I don't have as much experience here. But there's a big fallacy in the legal business. In the old days, 50, 80 years ago, law was a science. It's not a science. It's an art. It's an art. To answer your question, and he just mentioned it, it's the interpretation of the facts. If you have facts, A plus B plus C equals D, that's easy. No-brainer. But when you got two different, like in the statement, in the interrogation, two different versions, the defendant's version, real life, the agent's version. You've got to interpret which one is right. Second, always know your audience. We have made this a little more theatrical. Normally, we have a hardcore, tough, seasoned judge here, okay? One who is, no, seriously, who knows the law, wants these things quick, doesn't want to waste a lot of time, doesn't want to hear any emotion, zero, nada. And so, he, in a normal trial, is our focus, and the only focus. Okay? Here we play to you, more like a jury. And so we have to have every audience. When I speak in a jury trial, I have three audiences. First, the fact finder, the jury. The judge gives the law. But he's the one that decides the law that they hear. So I have to be nice to him. I can't make him mad at me, okay? I have to make the jury's happy and I have to make him happy. Okay. Then, to protect myself, because I have a tattoo. It's in Russian. Raditsa proigrat. If any of you know Russian. Born to lose. Okay? And that we lose as defense lawyers. I'm a prosecutor, I'm a winner now. But in real life, I'm a loser. So we will take it up to the appellate court. So my third audience is the court reporter, who's taking down every word. So I have to speak to you, the jury, to the trial judge and not make them angry, but at the same time, I'm setting them up for the appeal. And the last I'll come back with is a great author in the United States. He summarized Socrates. And he had three things that you had to have. First was ethos, logos, and pathos in speaking. Ethos, what are the qualifications of the individual? Now, you might thought it was a little emotional, a little very Chinese, very, very Chinese. That why go into this little personal stuff? But use the personal stuff with juries. But I have argued a court of appeals in the case where I had a case where a trial judge and a man asked for an attorney, but the judge didn't want to give it to him on the day of trial. No attorney. You will represent yourself. There was a brief recess taken. He went over and talked to the prosecutor and said, I'll recommend you don't get more than 2 years if you plead guilty. And then he comes back on the record and he says, I want to plead guilty. And the judge says on the record to the prospective jurors, thank you for coming today, but for your presence here, this matter wouldn't be quickly resolved. The issue was that the judge denied him a lawyer. So when I go before the learned jurists, there's 3 of them in the Court of Appeals. Tough. No jury arguments. Nuh-uh. You don't argue a jury up there. I came up and I said to the judge, Your Honors, I made a horrible mistake. I wasted 3 years of my life going to law school because all I needed to do was to talk to this trial judge who in 10 minutes told the poor defendant Here's how you try and represent yourself in a serious criminal case. They reverse the conviction. So I use my personal experience, but each is a different level, and it's a different audience, and you have to adjust to those audiences. Life is art. Law is art.
And also, I think this is also one of the responding to this count. So these implications just say, okay, because this is the routine way for the legal education. If you have nothing, no evidence, no facts, no law, then you count that. Why he counts it? Because there's no, just try to give the implication, imply that, okay, he has no law basis, legal basis, or has no facts basis. Why? That's why he answers. So this is also one of, probably it's also can be regarded as a debate in China, something like, so this is responsive for the way, that's why, so when we see, I think Mr. Ezekiel saying is legal education in the United States. So because the United States legal education is very universal popular, so everyone is almost the same. So this is probably in China maybe it's not because different law schools have different theory, different approach. So that's why you cannot say when I was studying that university, I was teaching that. He said, okay, different. I'm teaching at Tsinghua University, it's a different way. Okay, so. But anyway, so this is a personal experience is also most important. So this is just try to give people, so what's a common sense, or the common knowledge of the people. So this is it, I think. So we are not just, okay, so this also I think is very important inspiration for us just to know, so what is ethics, in particular when both the council gives very good, very good speech just on this concept. So now we move to the last section, which is called sentence theory. Okay, so after jury trial and defendant Young was convicted of false statement to FBI, the maximum punishment for his offense is 5 years confinement, and fines up to $250,000. The probation officer, in his presentence report, using the sentencing guidelines, recommends the probation. So serve 6 months confinement and pay a fine of the $250,000. So I read and consider each of your sentencing memorandum. So now we proceed this trial. So first we'll call just the defendants.
Thank you, Your Honor. I would suggest to the court that you follow the probation officer that prepared that report for you. The probation officer did not prepare that report for us. In his report, this very experienced probation officer, sir, recommended 6 months in jail. I believe that is fair and just. This is a 24-year-old graduate student pursuing a career in finance. As a result of this conviction, his entire career may be ruined. We may not have a chance at appeal, although, as you know, we have an obligation to pursue an appeal. But assuming that the conviction is affirmed by the Court of Appeals, this is severe collateral damage and punishment. So I believe that's part of what the probation officer considered. He considered the full picture. You have before you a young man who made a mistake. A young man who may have had sophistication even, I'll give you that, because he studied finance. So he knew what he was doing, no doubt. But he's 24 years old. His judgment is not fully developed. So what would I recommend to the court besides following the probation report? I would recommend to the court that he pay a fine of $255,000. In other words, the money that we suggested to the magistrate would be repatriated. The magistrate did not listen to us. That our client would be more than willing, we already spoke about that. He's going to do everything necessary to repatriate the $250,000 to provide to the court to give back to whoever the court believes are the victims. We believe that's more than sufficient punishment for the first-time offense of a young man that obviously made a judgment mistake of a great magnitude. As a result of that mistake, his parents have already paid for that mistake. They are terribly hurt. They were hoping that he would be better than both parents. One is a professor, one a doctor. Imagine what happened to their lives. So I would ask the court to consider that 6 months, he's been in jail because bail was denied. 6 months is plenty, with a $255,000 repatriation of that money. I do not call that a fine. He's been found guilty, we pursue that money was stolen. So he will voluntarily repatriate it, and that's an equity that the court can consider. Thank you, sir.
Well, thank you.
The government would respect and concur in the defense's recommendation as to the fine of $250,000. We think that that's a very admirable position. We respect the pre-sentence officer's report, which is a very thorough one interpreting the sentencing guidelines, and we recognize that ordinarily it would fall at 6 months confinement. But we think in this case, what we have here, yes, is a person without a prior criminal record, yes, from a good family, yes, a good student and appreciated by his professors, but also a smart individual, and therefore a responsible individual. And since he's already served almost 6 months in confinement, the court will be giving him, in essence, a pass to accept the recommendation of the pre-sentence report. And we think that in the interest of justice, the fact that this, against our system, when a person comes in and lies to an agent and goes out and literally gets a friend involved to come up to further the lie, aggravating the lie, that this court has discretion. We do not ask the maximum of 5 years. That would be unreasonable and disproportionate. We think that the moderate course, so the court can give a reasonable and appropriate sentence, would be 2 years and a fine of $250,000.
Okay, thank you. So considering the whole the facts and situations, so this court will decide 5 years probation and 6 months in prison and $250,000 fine. Okay, so this court will adjourned.
Thank you.
Thank you. So, do you have any questions about just, okay, so for the whole sessions, still talking about, so now this is for probation because you say the guy has actually convicted and was put into jail, and now support he can probation, that means he probably can just leave them in the custody for a certain time, they will be released before his sentence. So, and the first counsel actually is a very kind. I don't have to not really use kind, but anyway, they consider this guy, the characters of this, not the accused, not the defendant. So he talk of just considered and his characters and his future, his families, his whole situations, and give suggestions to that. So this is also kind of the different way for the skills of the advocacy. So to try to settle just to reach agreement on that. This is also part of that. So do you have any? So still just give you the last chance, last opportunity. Any questions on that? So if now I just to give the floor to the Professor Curry and to talk about his dream. So this is the dream, UX dream is also Chinese dream combined.
My Chinese students and American students call me Kong Wong Lao Shi. I'm the old guy, okay. And I was a lawyer for 44 years. I went to Russia for 8 years. I got a doctorate in Russian and Spanish, and I taught at Moscow State University in English and on human rights there on the European Court of Human Rights in Russia, which is a part of it. I came back to the United States and I wanted to learn another language, Chinese. So I studied 3 years at Xiamen University, and I'm still working on it. I'm in my 5th year of learning Chinese. I take 5 hours a week of Chinese online, and 1 hour with the teacher at my university, a very brilliant teacher who puts up with my bad Chinese. But whoa, I love studying Chinese, okay? And it's good for the mind, for an old guy. But my dream, and by the way, this exercise was his idea. That what we did today, it was his idea. He convinced me back in December that this was the way to explain the program. So my goal has been to bring foreign students to the United States. I brought American students for 10 years to Moscow. And then for 7 years, I brought Russian students to the United States. This year will be my 4th year bringing American students to China. And I teach a course, Chinese Criminal Justice. And what I teach is, my first name, my Chinese name is Ming Da Tong. Okay, Da Tong. We're more alike than we're different. And what happens is, in our society, we look at the differences. Well, you look different. Well, no, it's minor. It's not. In essence, we're the same. When you hear the systems, you exclude evidence. Every motion we had here is the same in the Chinese system. It's just a little different and a little quicker. But it's the same system. So my goal was, now I started bringing American students here. This is my 4th summer. So last year I started bringing Chinese students to America. 1 month. I wanted to make it unpianyi, okay? Very cheap. Because I wanted to get as many students as possible. And so the tuition is mianfei. Okay, it's free. Now, how do we get it to be free? You might say, because everybody says, it's slick. All the Chinese, it's too good to be true. It can't be true. Well, it's great lawyers like him that participate. We have 14 to 18 American lawyers donate their services. Some of them are the most famous in the country. The top-notch death penalty lawyer speaks to the group. We had the deputy chief legal counsel from Qualcomm. I'm sure you heard of Qualcomm, the big internet company. She is Chinese American, and she speaks to our group. We have 2 of the teachers who are Chinese American. And part of it is, I want to teach you, and this is my joke, I want to teach you how to speak Chinese. Now you all laugh and say, huh? Because why? You focus on the word Chinese in my statement. I focus on how to speak. And so what I'm trying to teach you is how to speak, whether it's Chinese, Russian, Spanish, English. It's the style. And you can see that our style is a little different from maybe other people. It's a courtroom, formal presentation. It is advocacy because it's adversarial. We come at one another. You notice in the sentencing hearing, he very skillfully co-opted me by agreeing I wanted the money, and he agreed to it. He stole my thunder. So I had to say, I agree with you on that, and the judge was impressed. So he didn't follow my 2 years, and he gave him 6 months, so he got the sentence that he wanted. Very slick, okay? But the point was, it's a style. And Chinese Americans we talk too much. Chinese talk too little. Your culture teaches watch somebody, listen to somebody, think about what they're thinking right now. Get the feeling. What feeling? I feel a little nervous, embarrassed. This guy is leaning down and watching me. That's how you think. That's your culture. And so what you have to do to become a good, that's an excellent trait. I wish more Americans had that ability to focus in on people like you do. But now you got to learn the other part, how to express yourself. He is extremely expressive. I don't know if he's had overseas training or not, but he's very relaxed. Why is it different than the rest of you? So it's different. You will be better than him if you take our 1 month course. Okay? I'm not saying this, and it's my goal. No money in it for, I lose money. I lose money on the program. But that isn't the issue. I want you, no ideology, no politics. You come up and you make your own determination. The Russians have a term I love, razvedka. I haven't learned the proper Chinese pronunciation. Reconnaissance, recon. Military unit goes out and checks the enemy's territory. It's called razvedka. In Chinese, I pronounce it wrong, but there's one meaning criminal investigation, the other means reconnaissance, and I think it's Chongcha? Juncha? Huh? Gencha, not the criminal investigation, the reconnaissance, the military. Huh? Gencha. The Gencha. Do a Gencha of America. No, seriously, and I don't laugh. How many of you been outside of China? Okay. And so the point is, go. When I first started traveling in the 60s, what country did I love the most? Russia. In our country, the evil empire. I said, oh, I love it. It turns me on. I want to see how different they are. When I got over there, they were just like me. Now, I want to give you that opportunity. So if you ask me, and he's absolutely correct, my dream, the Confucius Institute has done a documentary on it. Ming Da Tong in the summer programs. And so if you want to find out who I really am, take a look at the documentary. You can find it. And it tells you a little bit of my goal, which is to get you over there to see it. The course, we were very sophisticated because we're all sophisticated. Sophisticated judge, sophisticated defense counsel posing as the prosecutor. We know the business. You're not there to learn it. You learn the fundamentals. Exactly what the professor said here. Professor Liu is absolutely correct. It's to learn a style of communication, formal and persuasive. And you can do it. Each one of you can do it, but you have to reach out. We don't push the law. You go through a drill of acting out the role through 13 cases. We gave you 3 phases here. You don't have to do it the same way. We're expecting the lower level because your English isn't up there. But you go through it, and you have to act it out. It's not sitting and listening. Tonight you were very passive. This is very Chinese. Oh, we like to listen. No, don't. Bushi wan, you slow. Okay. And no. You got to talk. And part of it is that you get to see my country, and you get to see an opportunity. It becomes a chance to then spring out further to see what else you might want to do. We cover 2 cities. San Diego's most of our activities. We do all sorts of things. We go out and visit a maximum and medium security. Last year, the first thing they did, maximum security jail. Then a minimum security jail. Some of the Chinese students thought it was like a hotel. And then we have police ride-alongs, visit to the police station, several court visits, and we also have shooting. 4 of the female students, none of the male, 4 of the females went parachuting from 4,000 meters. Now that's not part of the course. Okay, they did that on their own. But the point is, when you're there, it's an opportunity to improve your English and to understand what it might be. I really got a wonderful, I didn't even ask for evaluations, and the students wrote up their own evaluations. Best thing I ever went through, never found something like this in the university. You made me think and act on my own. You taught me to speak. We had one of our teachers had all of the students shout. And some of the women students couldn't even shout. They couldn't scream. They were too restrained to do so. But part of it is we give it a chance for you to expand. The notice we had in the 1 month from going from very limited English up to very advanced. The problem is not difficult. It's a little complex to read. But this is the worst it gets. It gets only easier from here on. And the whole idea, as you can see here, is the interaction between the two. And the whole idea is speak up. We have a rule in our business. if in doubt, shout it out. And what it means is, most of us feel intimidated when we're around others if we have a view that might differ from the others. And to try to express it, first, be respectful. Second, be courteous. Third, don't be loud. And if you can do it, it's amazing how you can start to learn interaction. And we have a student hotel where we stay. If you want to contact the other students, you got to speak English to them because they're from all over the world. In the place, we go to a law school over there, which is only 300 meters from the place. We go to Las Vegas for 3 days. Some of you got the little brochure. You can see the courthouse where we were with the students from last year. The federal judge, the courthouse is named after him, and he's still alive. And he loves having foreign students. He had my Russian students for 7 years. Now he's had Chinese students for 1 year, and we'll hope to have you again next year. And with that, I would say thank you for coming. And if you had any questions for me about the program, I have my email address. I have also an alternative email address, which some of you may have, some of you may not. It's my China address. Real easy to remember. It's Cleary, my last name, John, China, and then at yahoo.com, because Google does not work here. So if you write to my Google account, it won't work. Thank you again so much. That's a little.
This is really just close just the street. So I think it's a good opportunity because it do not cost too much. It's generally I think totally is $2,500 just you should pay for your just travel expense and your living expense. There are no tuition fees. So have a 1 month experience in the United States. You meet with the very experienced lawyers, just as Zukios and Flurry, and also you visit the federal courts and some of the different places in the United States. Of course, it's up to you. So that's for us, so for me. So I think this is really worth of going and to experience to have the summer programs. So this is depends on you, but you have only to get the flyers. But of course, we have you can get it on the law school website because I put this information on the law school website, and you also have links. You also have application forms. So and also you can go. We have the IF Diary, yes. So we have the IF Diary. So this is one of the public domain, something like the WeChat. Or you can also go to the FDU, Human Rights. So this is one of the for us human rights basis. So you can get it. So all these informations. And if you determine to go, you can direct it to write to the Clary. And he is also he's Chinese fund, so he also has a WeChat.
Many have WeChat.
Yeah, the WeChat. Yes, you can just do that. So if you want just to have more information, just of course you can just to ask the Clary and to let him provide just the more information to you. So this is just for us, just this opportunity to provide opportunity to you. So as a professor here, I think this is worthwhile going. So that's why if you want us to taste some flavors of the U.S. just the most advocacy, so this is a good program. So this is what I want to say. Finally, I just before I end this, I would also like to extend my sincere thanks to the Clary and to Mr. Muskill and for their excellent, just professional, inspiring performance and